Alina Shaltsova. I'm an immigration attorney from New York. In today's live, we will be discussing the most interesting immigration news. USCIS is giving you more opportunities to control your case online. Changes to naturalization test. Good or bad? What's there to come? And of course, I will be also answering your guys' questions. So thank you very much for joining. Do not forget to like, share this video, and most importantly, type up your questions. So in the end of my presentation, I will be able to refer back to them, read them out loud, and answer them. I hope everything is good. I hope you guys are enjoying summer. If you have summer, where are you watching from? I know a lot of people are watching me from all over the world, and sometimes naturally you're going to have different season than me. I'm in New York, and it's been very hot for this past couple of days. So let me know where you're watching from and how you're doing. Hi Ali, hi Rana. Hi, Mr. Islam. Thank you for joining. Do not forget to like and share the stream. And do not forget to, again, ask your questions. And let's start. Well, USCIS is improving the way they serve you. You may be aware that there is sometimes a problem. You file a case, and for many applications, you have to appear for biometrics. In other words, you have to give the government your fingerprints, but sometimes you encounter an unexpected issue. A notice of the fingerprints come and you realize you cannot make it. You're either traveling or you don't feel well, or perhaps that notice never came, but you see in your online status for your case that there was such a notice sent to you. And guys, very often, inability to give fingerprints as scheduled results in denial or even loss of your status. It's especially true for non-immigrants, people in certain non-immigrant status that must maintain status. Most likely you filed for change of status to hop from one non-immigrant status to another, or maybe you're filing for adjustment of status. And if you miss those fingerprints, that fingerprint appointment, your case will be considered abandoned and closed. So now USCIS allows you to reschedule your biometrics appointments online. Previously, to do that, you either have to write to USCIS. The notice would actually contain a section explaining how you can submit your request for a schedule, or you would have to call USCIS customer service. Tell me, please comment, how many of you like calling USCIS? I would like to know, because I know I hate doing that, because it takes hours and hours, and the end result is always the same. You do not have any progress in your case. So I do not like calling USCIS. I'm sure you do not like calling USCIS. And finally, for people like us, USCIS announced that there is an online tool to reschedule your biometrics appointment. But your request to reschedule will be granted only if you have a really good reason for that, such as, God forbid, illness, or planned trip, or you cannot get time off work to come and do your fingerprints, or it is hard for you to arrange within a certain period of time transportation for your fingerprints. Some people live far away from the fingerprint appointment centers. Or perhaps there is a major life event, wedding planned, or maybe something negative, or any other reason. You share it with USCIS. These are just examples. USCIS determines whether you have a good cause for your fingerprints to be rescheduled. And if they grant the request, you will have to come to your new appointment with the proof that it's been granted. You're going to receive it by email or text message, and all of your fingerprint notices. It's extremely important. plus, of course, your identification. However, some people will not be able to use this online tool. For example, if you're trying to reschedule something that is scheduled within 12 hours, meaning that your current appointment is going to take place within 12 hours, you will have to call USCIS. Or you already missed your appointment. Or, for example, you cannot use online tool because it's not working for you. So if the online tool is not going to be working for you, you still have to call. So in those cases, you still have to call USCIS and deal with the customer service. Or maybe at some point, even that will be eliminated and your life will become a little bit easier. But for now, if you have very urgent request, or also forgot to mention, it's your third time that you're requesting to change your appointment, then you will still have to call USCIS customer service. I trust you know this number by now. If you're dealing with USCIS, it's very easy to find it, uscis.gov, and you will have to prepare to spend significant time with them online trying to reschedule your appointment. And I have to tell you that it's extremely stressful. Even if you call that number, you will have to have some proof that the appointment was rescheduled. And it's tough sometimes, it just doesn't come. The number is 1-800-375-5283. This is in case you cannot find it online. Second interesting piece of information I wanted to share with you concerns naturalization test. You may be aware that this current administration is working on changing the test for naturalization. Anybody who would like to become a citizen in the United States must pass this test. I have to say that I had to take it a number of years ago, and it's pretty easy. It was pretty easy for me. The English portion of the test consisted of literally me answering one question and repeating one sentence. Of course, the officer asks some security questions in English and history test. But again, it was very easy. All I had to do is to answer 6 questions correctly out of 10. And this is the current version of the test. You answer history questions correctly, 6 out of 10. That's all that is required. And if multiple answers fit the answer, you just need to know one correct answer out of 3. And speaking portion of the test is pretty easy. But the test is going to be more difficult very soon. The speaking portion of the test will consist of you having to describe what is shown on a photo or picture that immigration officer is going to show you. I think personally it will be more difficult for most applicants to pass this portion of the test. How well you have to describe it, how elaborate you have to be in the choice of words that you're going to be using to describe something. I'm not sure what the threshold you will have to pass here. Another issue with the new proposed test is that it's going to contain multi-choice questions and answers. And now, for the question to be counted as correctly answered, you would have to know all the correct answers related to a specific topic. You will have to significantly improve your knowledge of the United States history. And I'm not the only one who's concerned about this new developments in the test. There are a lot of advocates who are voicing their concerns. Of course, if you have a choice as to when to file for your naturalization, I would say file now, before the new test comes into play Even if you are confident that your English is very good and you have an extremely good memory, just in case, because I anticipate that after the new test is going to be implemented, which is set to happen next year, in the end of the next year, there will be a certain period of time when people are not going to be sure, especially officers, how to grade you. And I would anticipate that there will be some denials related to this issue, unless, of course, the new proposals will never actually become the law, the regulations, and they will not be as strict as they're promising to be. So we're going to see. So these are important things that you need to be aware of if you are in immigration proceedings. USCIS online tools are expanding, as you see. I personally do not trust them as much, but hey, with time they get better and better. And now, if you guys have questions, I'll be happy to answer them. Hi, Lee. I'm watching for Dignity Program and Citizenship Act 2023. Yes, thank you, Ali, for joining. No news, unfortunately, with regard to immigration reform. We do have some negative news from Florida, and I had a separate video about that. This is the new law in Florida that is going to punish people who employ undocumented people, and is going to also make it a crime to transport somebody who is undocumented to Florida. A lot of people will not be able to use their driver's licenses if they're issued and in states that allow driver's licenses to those who are undocumented, and your driver's license is not Real ID compliant. So we're going to see what's going to happen in Florida. I know that many immigrants are already leaving Florida. They're moving somewhere else. And I think the industries such as tourism, construction, food industry are going to suffer pretty badly because of these new provisions. But we're going to see. So see, unfortunately, we don't have good news here. Hi, Erwin from the Philippines. Hi, Elias. My wife was in immigration court for removal. I'm a US citizen and we got married 7 months ago. And I applied for her I-130 marriage-based. Our immigration court master hearing got dismissed by, I think I lost you a little bit. Let me see. All I can tell you, because I didn't get to the end of the question, this is usually a normal route. If you have I-130 pending or approved, you don't have any issues in your case, you do have a legal entry, court and the prosecutor usually would agree to dismiss one's case so that they can adjust status with USCIS instead. So the courts love dismissals these days, I have to tell you. I actually, interestingly enough, spoke to a reporter today about the fact that courts are dismissing a lot of cases. And I know many of you do not really understand what dismissal in court means. It means that whatever you filed in court is no longer pending, including an asylum. Most likely, if you agree for your case to be dismissed, you will not be able to renew your asylum claim anymore. You also are going to use any pending approved work permit, because usually work permits are approved based on a pending underlying application. So when your case is dismissed in court, your underlying applications are closed. So before you agree to dismissal, unless you have clear chances of receiving your status before USCIS, think about what you have to lose. Ask your attorney to explain you again and again what you're going to be losing when the case is going to be dismissed. Hi, Andrea. I'm currently TPS, El Salvador holder. My parents became green card holders from my brother sponsoring them. Can my parents sponsor me now or wait until they have citizenship? I'm unmarried, 28 years old. Andrea, your parents can submit for you I-130 petition as long as you are unmarried, but you will be in preference category, and you will be able to use that petition 6 to 8 years from now if everything goes well. 6 to 8 years. You will have to show that you are in lawful non-immigrant status at the time when you will be filing for adjustment of status. Now, you mentioned you have TPS. TPS holders, those who travel on advance parole and come back, are considered to be in good status for adjustment of status purposes under preference categories. So if it's going to be true 6 to 8 years from now, then you should be fine. Or if you find an employer who can sponsor you now and you travel on advance parole related to TPS, you can fix your status much faster, provided you do not have other issues. I'm actually working on a video, adjustment of status video, just so you guys will have a better understanding how adjustment of status works and what you need to watch out for. Okay, hi Elias, this is the second part of your question. The judge dismissed the case, can we submit I-45? If your wife does not have inadmissibility issues, she has a legal entry, she's never been charged with misrepresentation or fraud, no criminal convictions, any other potential issues, never claimed to be a US citizen, she, generally speaking, or a hypothetical person, generally speaking, after the judge dismisses their court case, should be able to file for adjustment of status before USCIS, okay? And then you're also going to be asking for the work permit in the meantime and travel permit. Hi, Abdul. Hi, Erwin. Hi, Nabil. If you guys have more questions, please let me know. Hi, George. Hi, Shah. Hi, Sustainable Grill Builder from California. I like your nickname. All right, I think some people would like to know if I issue tourist visas. Immigration lawyers do not do that. Immigration lawyers do not issue any kind of visas and generally do not send any kind of letters of invitation. If somebody would like to come to the United States as a tourist or a visitor, they simply can file an application with the consulate. However, it helps if you can show that you do have somebody who's inviting you here, such as your family member or a friend. But remember, when you go for that tourist visitor's visa, you must show that you do not have an immigrant intent. In other words, you have to show that you're not going to stay permanently in the United States. So I feel that many of you are interested in some permanent solutions rather than temporary solutions. And then you have to look at such visas as H-1B, E-2, L-1, EB-2, EB-2 National Interest Waiver, EB-3, or EB-1. For most of these visas, you will have to have an employer filing petition for you. Some do not require that, such as EB-2 National Interest Waiver or EB-1. But most petitions will require an employer, which an immigration lawyer is not an employer, which just assists you guys with services. Hi, Vera. I have already attended biometrics appointment more than a year ago, but I haven't received my work permit for U visa. What should I do? Yes, unfortunately, U visa work permits are significantly backlogged, and I really do not know when you will be able to get one. I have no clear timeline. I don't think anybody can answer this question. after USCIS announced that initiative, to give work permits to those who are in the U visa long wait lines. I haven't seen that many work permits actually issued. So if you have a different experience, whoever is watching, please comment, share your experience on that. But most of my clients have not received those work permits. Thank you, Abdul. Thank you very much for your kind contribution. Hi, Sunny. What about 290B processing time? I have to tell you that it varies. Sometimes you file I-290B, motion to reopen or reconsider, and you receive an answer within 30 days. But most of the times, I think it's going to take 9 to 18 months to receive a decision on that motion. Hi, Kisman Disida. I'm from Michigan. Can I apply for a green card if I've been here 9 years and I have a work permit since then from Asylum? Probably not. If you just have a work permit and you are in asylum pending status, to qualify for the green card or adjustment of status, you have to have your asylum actually approved, okay? But if it's only pending asylum, then it doesn't allow you to file for the green card just because you've been waiting for a very long time. I know it's extremely frustrating, but that's unfortunately what it is. Hi, Seonejen. I'm sorry when I mispronounce you guys' names. I know my name is not the easiest either. So I'm going to make a good video on adjustment of status. So it's going to help you guys to understand what adjustment of status is, when it can be granted, and when it will not be granted. And generally speaking, adjustment of status is a term of art, term that we use to describe the process of receiving a green card in the United States, opposed to getting an immigrant visa from overseas. Hi, Stefan. I have a TPS and asylum case in court pending. Can I travel with my advance parole? I don't think so. I think you have to close your pending case first. That would be my advice to you, even though I don't think that there will be any real repercussions for you. But if I were you, I would close that case, because technically, if you have an open case, that notice of appear serves as a warrant for your arrest. So I don't know who you're going to meet at the border. And I know that when you already have case closed, you can travel on your advance parole, no problem. Even if you have an order of removal and you receive TPS advance parole, you can travel, no problem. Okay. Hi, Alina. When I can apply for green card after it is approved by immigration judge? Excellent question. Believe it or not, you do not have to do anything. According to USCIS, they will mail it to you. That's what they said in the USCIS announcement. But if your application for a green card was approved with immigration judge, you should call USCIS. Let them know about that, and they will issue an appointment for you to come to USCIS field office, and they will process, I think, your fingerprints. They ask you that you bring 2 passport style photos, and at some point they mail you the card. That's been experience of my clients, recent experience. But about a month ago, USCIS stated that they will be automatically sending you the green card. Yet they still advised you to call, just in case. Hi, Susie. My sister's court appointment got moved all the way to January from July 5th. They just said something about switching it for someone who is detained. How can they do that? Oh, yes, they can do that. You see, court can do whatever they want with the calendar. There is not much you can do about that. Only if you have a very good reason to advance your hearing date, you can file a motion asking for the date to be moved. But for the court, for you, it's a long time, from July to January. For court, it's nothing, because they have so many cases. They're so busy. they will say it's going to take us longer to consider your request than to move it. Hi, Tijuana. Good day. I was detained. Came in November 2021, December 2015. Can I expect my appointment? I'm not sure what those letters stand for, so if you would like to type up your question again, I'll be sure to try to help you out, okay, and try to answer it. I just don't want to guess. What if I guess something inappropriate? Hi, Pitvan. Hi, Lena. I have asylum pending status, but case was removed from master calendar. Now my job is filed my I-140, which is also pending. Is there anywhere I can apply for adjustment of status? Well, before you decided to deal with your job, I-140, you should have consulted with an attorney about your potential adjustment of status application. Adjustment of status can be filed based on employment only if you can show that you maintained legal, lawful, non-immigrant status from the time of your entry until the time you can file for adjustment of status, minus certain very narrow exceptions. To my knowledge, those exceptions, apart from 245I, are not favored in New York. It can be a different story in the state where you're at. So my guess would be that no, you will not be successful in adjustment of status just based on your question because you're already in removal proceedings. But I do not know everything and everything else. Perhaps you're just trying to renew your adjustment of status application. That may help you. But you see, most likely not. Ask your attorney to or consult with us. Show me your papers and I'll be able to answer it better. Hi, Samir. I have I-601 waiver application. I have biometrics appointment. When can I get work permit? You cannot get a work permit based on an I-601 application. Maybe you have something else pending, like I-45, then you can expect work permits, and usually within 3 months after filing, sometimes much later, sometimes never. Some work permits just do not come, but right now, if you filed for adjustment of status based on marriage, even if you had to submit I-601 waiver, then you would have to wait about 3 to 4 months to receive the work permit. However, you have to know that I-601 by itself does not give you any work permit spaces. And I'm going to take a last question for today. I know I skipped some earlier questions. Hi, Ibrahim. How long does it take for you to get work permit if you submit it after you spent 8 months in the USA? And how can you get green card if you enter the country at the age of 17 as an immigrant? Ibrahim, just because you are in the United States for 8 months, that fact by itself does not allow you to file for the work permit. If you filed for asylum and your asylum application has been pending for 150 days, then you can submit for the work permit. Usually it comes very quickly, in about 45 days after you submit for your first work permit based on asylum pending. The work permit on asylum pending cannot be issued earlier than 180 days passed from the time when you filed for your asylum. Now, second part of your question is, how can you get a green card if you enter the country at the age of 17 as an immigrant? Currently, just because you entered the United States at 17 as an immigrant, you will not be able to get a green card. Immigrant also not sure, did you have a status, did you not have a status, but I assume that you entered the country, overstayed your visa if you had one or never had a visa. Currently, there is no opportunity for kids to receive a green card just because of these facts. Now, it may change if immigration reform passes. If immigration reform passes, then you may have some chances. But right now, to get a green card, you have to be sponsored by usually a family member or you can sponsor yourself if you're still under 21, special immigrant juvenile status. Some children who are under 21 can receive green card in the United States if they can show that in their home countries they've been, or in the United States, they've been abandoned, neglected, or abused by one or both parents. It's called special immigrant juvenile status. I have a lot of information about it on my website, shautsova.com. I have little videos here on YouTube, on TikTok, guys, a lot of information about that. So this is going to be it for today. Thank you guys very much for your questions, for joining, for sharing. I hope I helped at least some of you out. And if I didn't answer your question today, I promise to answer it next week. So next week, join our live. Say, Alina, you forgot or you didn't answer my question. Or you can book an appointment with me, and I will be happy to go over your situation, spend more time with you, thoroughly answer all your questions so we don't have to rush, see how we can improve your situation, how we can fix your situation. Sometimes clients call me just for a second opinion. Sometimes clients tell me, I really do not know what to do. Sometimes they need their case to be saved. Like I made a video about this. Client received a NOID, notice of intent to denied. Some clients even got denials, and we're working on the appeals. So I prefer, of course, if you come to me earlier so we don't get to the point when we have to be on the defensive side. But life happens. You know, I know that sometimes you think, I'm going to go somewhere cheaper and find something easier. Listen, sometimes it works out. Most of the times it doesn't. Because cheaper means also less time is going to be put into your case. It's important. Sometimes I can't help you because nobody can. There are situations where I honestly say that it's not possible for me to save or to make a case or do anything for you. That's also something that I would think you would prefer to know up front, right? Honest answer. But if there is any chance, I'm going to tell you honestly about what the chance is, I believe, and what we need to do for that. So guys, thank you very much for watching. If you need to find me, 917-885-2261 or shautsova.com. And